Camera action. Welcome to Idea to IPO. Hello, I'm Jennifer, and Idea to IPO has been holding tech startup events in Silicon Valley for many, many years. We organize venture capital panels, legal workshops, networking events, and more. These days, we are 100% online, and we hold an event nearly every day of the week. Please check out our schedule at ideatoipo.com. Our featured speaker today is Dr. Stephen Colby, and he is the top intellectual property attorney in Silicon Valley. And he's also passionate about helping entrepreneurs succeed. Ladies and gentlemen, Dr. Stephen Colby. Dr. Colby, please take it away.
Okay, thank you, Jennifer. I think I'm top just because I like your bird. I say things nice about Yoshi. So anyway, folks, welcome to Patents 101 for Tech Entrepreneurs. I'm going to be talking for about an hour today, and then we'll leave half an hour for questions. If you have any questions, please add them to the question and answer tab of the in Zoom. I will go through that list first. I might notice a question as I'm talking, but the best luck you will have in getting me to answer a question is at the end of the talk, and I'll go through all the questions together. I want to give a little bit of a disclaimer. Attending this meeting doesn't mean that you are a client of mine, right? That takes a formal agreement. I am a California attorney, and I'm also a patent attorney. So there would have to be a formal agreement. At the end of my presentation, we will present my contact information, my LinkedIn, things like that. So if you want to reach out to me afterwards, that would be great. So my goal here is to give you a little bit of background about patents. And my hope is that next month or the month after, I'm going to give a different talk, kind of along the same lines, but I'm going to do a deep dive. Instead of just talking about high level of of IP and patents and various things, I'm going to actually take a bunch of patents and analyze it for everybody, right? Go section by section through the patent, explain what each section's about, why it's there, what's good things to have there, and what's bad things to have there, and so on. And the goal of that presentation will be to get you better to understand a particular document, a particular patent or patent application. Right now, today's presentation is going to be at a higher level. So it's going to talk, hopefully at the end, you'll understand a little bit more about the importance of value of patents and other types of IP to your business. And this presentation is going to be primarily directed at entrepreneurs, people just starting off. The next presentation will be for any decision maker, C-suite people who are running big companies, people who just want to get a little more understanding about how to read a patent. Okay, so let's get on with this one. We're already 3 minutes in, and click. Okay, the first question is, what can you get, right? As an IP attorney, I primarily focus on patents, and I'm the type of patent attorney who's called a patent prosecutor. That means that what I do is I help write patents, and I argue in front of the patent office about getting them allowed and what claims my clients should be able to get. I do a little bit of litigation. I have one litigation case right now that is almost 6 years old, just to give you an idea of how long things can last. Part of that is because of COVID. It did delay things, but there are other types of intellectual property attorneys. There's ones that also do trademarks. It's common to have people who do both trademarks and patents. I pretty much hand trademarks off to people who do strictly trademarks because they're specialists at that. There's also copyright and trade secrets. I'm going to talk a little bit about the first three that are on this slide first, just so you understand the difference between these and patents, okay? Copyright is the type of intellectual property protection you would get on a book or a painting or the layout of a web page or maybe even of a logo, right? It is for the artistic representation, the creative representation of something. A copyright can be on a painting of a bunch of fruit. That doesn't mean you own all paintings on it with a bunch of fruit. You own that particular image, right? And you could own various different rights to it. You could have the right to use it in an advertising, but not the right to change it. You could have the right to sell it to somebody else. You could have all kinds of different rights that somebody could give you. Copyright starts off with the person who does the creative work. So if you do hire somebody to do something, produce something for you, you want to be sure that it's considered quote unquote a work for hire, and that the IP gets transferred to your company or to you or your business. Right? That's going to be true of a lot of the stuff we talk about of the IP today. You always have to make sure that you own it. Trademarks are meant to represent goods and services, specifically represent goods and services, right? So 7-Eleven in the United States here is a chain of convenience stores. It is a trademark representing that product, that store, right? The owner of 7-Eleven is a business called Southland Corporation, which nobody has ever heard of. They also own Taco Bell and a bunch of others, right? So trademarks represent goods or services. They're not necessarily the name of the company. They might be, I remember when I was a kid, maybe 13 or 14 years old, I got hired to work for a plumbing company, and I was helping them lay ditches, right? And the name of the company was Teddy Bear Plumbing. Okay, that is a good trademark because I still remember that decades later, right? And it had a little cute logo of a teddy bear, right? That's an example of a trademark. Okay, they probably had a business name, right? An official company name that was different than Teddy Bear Plumbing, but who knows, right? So trademarks represent the goods and services, not the technology under those goods and services, right? Trade secrets are things that are of value to your business that you intend to keep secret. And that could mean a big variety of things. It could be neural network algorithms or configurations. It could be chemical formulas and processing. It could be your pricing information. It could be your customer prospect list. All those are good examples of trade secrets. And occasionally you'll hear about litigation about trade secrets. For example, a company with one self-driving car might sue another one for theft of trade secrets, right? The thing about trade secrets is, in order to make them valuable, it really helps if you document them. So pretty much any business, if you're starting a new startup, especially a technology company, you want to write down a list of what all your trade secrets are. And some of them might be specific bits of code, how you're doing stuff, right? Some of them may be your marketing budget. You know? These are trade secrets. And if you write these down, and if you have a program saying, oh, everybody in the company doesn't get access to this code or access to our sales prospects data, right? You actually keep it as a secret, you document it, you have some document that you keep in a safe that describes this is our trade secret. And when somebody gets permission to access that trade secret, right, you have a log of these are the people who are allowed to have it, and they acknowledge that when they get access to that information, they're going to sign a little paper. I understand this is a trade secret. That's a trade secret program, and it can make your trade secrets really valuable. Because one of the biggest defenses against misappropriation of trade secrets is, oh, that wasn't a secret. I heard this discussion at a bar at a trade show. Boom, right? That's no longer a trade secret. You can lose trade secrets that way. So the thing we're going to spend most of our time on today, and my favorite, is patents, okay? So there's a bunch of different types of patents, and let's talk a little bit about that. Okay. There are more than just 3 types of patents, but I'm going to focus on these 3. A provisional patent application, right? There's no such thing as a provisional patent. It's a type of application. A non-provisional patent application will hopefully eventually issue as a utility patent, all right? I also often see design patent applications that turn into design patents. There's other types of patents. There's, for instance, patents on plants, right? That can be, in some industries, those are really important, but these are the ones that I run into most days. And I'm going to talk a little bit about each of them right now. Okay, let's start at the end. Let's start with design, because get rid of that, okay? A design application and design patent is directed only at the ornamental features of something. It's not supposed to be the functional features, right? If there's a feature that has some really important functionality, that's not appropriate for design application. Good examples of design applications are car hubcaps, right? You get lots of, or tire treads. That's a good example of a design application. One of my favorite design applications was by Polycom. And this was always a great example because in the old days, I'd be giving this presentation in a conference room, and there'd be a Polycom speakerphone in the middle, and it has this nice triangular shape. Well, it turned out that was one of the more valuable patents that Polycom filed in there when they were first founded in the early days. It turns out that that shape is great because you want to have a speaker in the middle and a ring of microphones on the outside. And either you go for the flying saucer look, or you have this cool looking triangle. Right? And it made a real big difference. Polycom's competitor went with the flying saucer look, and it did not look as good on a conference room table, right? So that's a good example of a valuable design patent application in technology. Design applications are only good for 14 years, and they're relatively modest cost. They should only be a few $1,000s. Most of the cost is in developing the right drawings. And I recommend working with somebody who specializes in design applications, because just how the drawings are done can really affect the scope and the value of the patent application and patent, right? So, okay, now let's talk about the provisional application. Provisional applications are really useful. They have a lot of pros and a lot of cons. So let's talk about it now. These are intended to be used as a placeholder. They're an application that gives you literally a stake in the ground. Well, not literally, but you know what I mean. They give you a stake in the ground, and they only last for 1 year. So the advantages of a provisional application are they are quick and easy. They can be done for on a really low budget. One can slap a cover sheet on a design document or a scientific paper that's about to publish, or whatever good piece of documentation you have. Sometimes a PowerPoint presentation from a lecture that's about to be given. That could be filed as a design application. So it's really informal, right? It doesn't have to meet the exact requirements of a non-provisional patent application, right? Because of this, it can be really inexpensive. It means that you don't need to have an expensive attorney write the whole thing, right? It only lasts for 1 year. In that 1 year, you have to file a non-provisional patent application claiming benefit of the provisional. So in the cover sheets of a non-provisional application, you actually have to list all the provisional applications you're claiming benefit of. And that will give you the filing date of the provisional application. You'll get credit for that filing date. So there's a couple of reasons you might want other than the cost. Right? And I deal with lots of startups that are just trying to bootstrap, that are just bringing, they're working on a budget. And my advice to them is do some provisionals and wait till you get some funding. And when you've raised a few $100,000, then do the non-provisional application, right? Remember, once you file the provisional, you have 1 year to do that, okay? So it kind of puts a clock on you. File the provisional and put everything you've got into your business. And hopefully you'll have raised money to pay for a full non-provisional application afterwards. So the provisional application protects you from early disclosure. So in the United States, if you offer something for sale or use it publicly, you have 1 year to file your application. I'll talk a little bit more about this later. But in the rest of the world, you don't have that 1 year. And that means that if you do a presentation at a trade show or give a lecture at a scientific meeting or put a white paper out on your website, that material can be used in a European patent application or a Chinese or Japanese patent application. That material that you've publicized can be used against you, right? And you don't want that. So if you file that as a provisional, you've got a filing date on that, just that material. It's whatever's in that document. You're protected for that, okay? A disadvantage of the provisional application is because it's quick and easy, it's very often really sloppy. It doesn't have, I file design applications that are 10 pages long, 5 pages long, provisional applications that are 5 or 10 pages long. And they clearly don't have the meat that a 30 or 40 page, a full patent application has. There's a lot of stuff missing, right? If it's just your PowerPoint deck that you're going to present to investors, clearly there's lots of technical details you're not going to be talking about there, right? It may prevent that presentation from being an early public disclosure, but it doesn't have enough meat to it in order to really support later claims in a non-provisional patent application. So people get in trouble. They'll put in a design application. They won't have spent enough time with an attorney, for instance. They won't have the right stuff there, right? It won't have the right language. And so it doesn't help you as much as you're going to think, right? So there's a balance. If you're doing the provisional applications, there's certainly times when it's just throw a cover sheet on and get it out there, but realize that that may not give you everything you need. Then there's the times when, okay, we have a really cool new idea. Let's write that up and try to get as many details as we can, quick and easy, and get it as a provisional application. It might be in 3 months, we decide this good idea is not so important. Well, it's a good thing we haven't spent thousands of dollars on a non-provisional application and then decide to let it go by the wayside. You can file, in your first year as a business, a bunch of provisional applications as new ideas come, as the business makes a 90-degree turn and goes off in some other direction. Well, it's a good thing you're only spending money on provisional applications because some of them may not be so important anymore. Okay, the non-provisional application. This is the one that turns into a patent, right? It will give you enforceable rights. It will last 20 years from the date of filing of the non-provisional, if you pay all the fees and keep it up, etc. I note 20 years from the non-provisional filing, which means the provisional gave you an extra year. That's kind of nice, right? And I have, in my practice now, I'm at the point where things were filed 20 plus years ago, and it's great to have that extra year, right? A non-provisional application really should be prepared by a patent attorney or somebody who's really good at writing under the direction of a patent attorney. It takes about 5 to 10 years for patent attorneys doing this full time to really get good at writing patents. That's my personal opinion. So if you're a newbie, my suggestion is talk to a patent attorney who knows what they're doing and who regularly does stuff in your field. For example, if you have a software application, talk to a patent attorney who does lots of software, right? Okay, what does the patent give you? Aha. It gives you the right to exclude others. It doesn't give you the right to do anything, right? So, iPhone. If I were to write a patent on an improvement on this phone, and I were to get a patent application on that, and I were to get a patent on that improvement, it wouldn't give me rights to make my own phones, right? It's only the right to exclude. It's not a right to do. So pretty much every patent application, every patent out there is an improvement on something else, okay? There could be underlying patents that are owned by other people that block the practice of what's in that patent by most entities in the world, right? Okay? It gives you the right to exclude importation into a country, right? It gives you the right to prevent manufacturing, okay? And use. Let me say something about use. Public use is important, especially when it can trick you, right? So I'm going to give an example. If I have an app on an iPhone and I show it at a trade show, and all the real functionality is off on a server somewhere, that still counts as public use of that server. Now, this law, believe it or not, came from the 1800s, or this rule about what is and isn't public use. And it turns out that it was somebody who had invented a new way of putting whale bones in a corset for women to wear, right? And he put his wife out on the street with this corset on underneath. And of course, she had lots of layers of clothing on top of it. But the result was that her profile was changed, and she looked, in those days, more in a more desirable way. That was considered public use because the effect of the hidden herringbones underneath was seen by the public, okay? And if you have software running a server and the effect of that software appears on an iPhone, that's considered public use of everything in the server, right? In this list here, it should probably also be offered to sale, right? That is something that can be considered that you have the right to block, right? Patents are per country, okay? That means that if I have a US patent, it's not enforceable in Europe or China, okay? If you want protection in other places, you need to file protection outside the United States. And it turns out there's ways to do that. It's relatively expensive, but fortunately, there's treaties and there's types of applications you can file that will put off a lot of the expense, a year or 18 months, not 18 or 19 months from when you would otherwise have to do it, right? So there's what to do that, but keep in mind, if you're a startup, you will likely only have patents in a few countries. And you'll sit down with your patent attorney and figure out, okay, we really care about a couple of countries in Europe and Japan and Korea and Australia, right? And then you'll do those countries. And hopefully, in the US, of course, hopefully that will take a big enough of the market so that nobody really wants to compete with you, right? So it's a per country situation. We do have some places like Europe where there's one patent office, the European Patent Office, and applications are examined there. And if a application is allowed, then you say, okay, I want France, Belgium, and Germany, all right? And then you pick the countries that the patent will actually issue in, and you'll find yourself with a French, a Belgian, and a German patent. And those can get expensive. There's fees that you pay every year on to keep them alive and so on. So you'll talk strategically with your attorney on exactly which countries make sense to go into, right? Okay, let's talk about really what's in the anatomy of a patent, all right? I don't have one here, do I? Looking around my desk, everything's electronic these days. Anyway, at the beginning of this presentation, I mentioned I'm gonna do a presentation that's just on this subject, okay, how to read the patent. The first part of a patent on the cover sheet is a bunch of data. What was the filing date? What priorities were there? Who were the inventors? And when did it issue? Those are kind of the things you want to know, right? The priority date can matter. It could be that somebody is, and we'll talk a little bit about this in a minute, but it could be, and literally I'm doing that next month, that somebody is filing a patent application now that has priority that goes all the way back to 15 years, 17 years in this case, right? So you can go get, you can keep a patent family of applications alive, and you can have priorities that go way back, right? That's the type of thing that will be listed on the front page of a patent, okay? The specification is a description, right? That's where all the columns of words are. And it describes a lot of technology. A lot of it is probably old, right? Or some features that are found in other places. It's common that somebody will come to me and say, oh my God, somebody got this patent on blah, 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 on basic encryption. And then I look through the patent application. Sure, there's lots of discussion of all these basic encryption, right? But there's more. Okay? And we'll get to the claims in a minute, hold on. Then there's the drawings, the figures, right? It's very unusual for patents not to have figures, unless they're, for example, chemical patents. Then you just have the formula. But most patents have figures. And they can be elegant mechanical drawings. For things like software, it's usually block diagrams and flow charts, maybe timing diagrams or something like that. But there's a set of figures, and they should have items in it that have reference numbers that refer back into the specification, right? And the most important part of a patent is the claims, right? The claims are what the person is getting the rights on, okay? Not everything in the specification, right? The person who came to me who said, oh my God, they got a patent on basic encryption. Well, there's a lot of description in the specification, but there's just a couple of paragraphs that really, really matter, okay? That have some new features of new ways of doing things. And those are highlighted in the claims. A patent is infringed if somebody does every single thing or has every single thing in one of the claims. So you look at claim 1 and you read it and say, this is a water bottle, all right, with a handle and a flip top lid that's kind of nice and a little button that locks it so it doesn't come open in your backpack. And then when this is unlocked, it has a valve. There's a list of elements in the claims. And somebody has to have every one of those elements to infringe. If they are missing one thing, that means that they don't infringe. And so it could be that the little rubber gasket in here is the subject of a patent. Right? Water bottles with rotating lids have been around forever, but the way this rubber gasket in here seals could be one of the elements in the claims. And that element is what made that claim allowable, right? I'm just talking hypothetically. I have no idea really about patents on water bottles, but that's how it works. You got to look through the claims. And if there's something in the claims that you don't have or do, then you probably, of course, you got to consult with an attorney, you probably don't infringe that. On the other side, in order for a patent to be allowable, right, there can't be anyone who's done it before or any combination of obvious art from before that lists everything in that claim. In order to be allowed, in theory, the patent examiner should have looked at it and agreed that, okay, there's something about this claim that's different than that's either original or non-obvious from what was before. So reading the claims and understanding the claims is really important. Kind of a little side part to this, and here's a quiz for you, okay? If I have a claim with lots of stuff in it, is that a broad claim or a narrow claim? Think about it. And I have, again, people come to me and say, I got a patent on this fantastic system. It's got everything in it, right? Every little piece of my doohickey is listed in this claim, right? Well, that's a really narrow claim because in order to infringe that, somebody has to have every single one of those little pieces, right? So the person who comes to me with a patent claim that's a column long in a patent, I look at it and I just shake my head. Well, all somebody needs to do is find one thing that they can avoid in here and not do that and not have that, and they avoid your patent, right? Or at least this claim, okay? So be aware and understand a claim that's narrow, that has fewer amounts of words, is probably broader, okay? Compared to just looking at the number of limitations, the number of words in the claim. So in your patent, the one that you're gonna get, you want a combination. You want some claims that look really narrow or that look really broad and some that are really narrow, right? You'll have a combination of both because if you actually ever fight over your patent, you want to have some breadth. The broad ones might get knocked out and be found invalid, but some of the more narrow ones might save you the day for you, okay? So that's the anatomy of a patent. And again, look for this presentation. I'm gonna have a new presentation that's gonna discuss that, and we're gonna look at actual language in patents and talk about it. Okay. Boom. When should you do this? Okay. There's a song by the Beatles, right? Yesterday. Da, da, da. All right. Very often, I'm the first attorney that people come to. I mean, before the corporate folks. I take clients with an idea and a half a filled out napkin. All right. I've got this idea, blah, 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 right? And the reason they come to me first is they want to start talking to investors or other people or gabbing about it, right? They don't want to be stealth for too long. They want to at least get money. So getting initial provisional applications to cover their early ideas is kind of a nice strategy. And it's a good way to bootstrap your business, right? Getting these inexpensive provisional applications. It might be that in 3 months you decide that really wasn't a really good idea and you've moved on to something else. Unfortunately, you've only spent money on a provisional and haven't spent a lot more amount of money that would cost for a full patent application. I'm going to pull up something on my desk here. I guess I can show this. This is a mock-up. Guess what this is, right? I can't tell you the details about it, but this is a drone. Okay, we were working on this last couple of days with a client, and I can't tell you what's special about it, but this is the type of thing, you know, early day stuff. Okay. Anyway, that's the fun part of this job, is working with new ideas, with new entrepreneurs who are just trying to start a company and trying to figure out when to do it. Now, it's a first to file world, right? It is, that means that getting your idea in first matters. And I have seen cases where companies are days, you know, 10 days apart. Okay. I've seen, you know, less than 2 weeks where it's really critical, right? And somebody got something in and it's like, whew, that was close, right? Or, right. Okay. So getting it in, and that's again another advantage of the provisional, you can do it quick and dirty. And that, of course, starts the clock. You need to be a functional company with money to do stuff. I mean, I will talk about money later, I promise. Within a year, because you're going to have to convert that provisional application to a non-provisional application, right? All right. Well, next question. Why would you do this? All right. I see people do presentations, pitch presentations for investors, and then there'll be the question and answer section. And the investor will say, what about the competition? And the entrepreneur will say, oh, we don't have to worry about competition. We've got a provisional patent application. I'm sorry, that is the wrong answer, okay? That provisional will be a patent in maybe 4 to 5 years. And if there really is competition that is more powerful than you, you will be dinner, right? You'll be the little guy here who's about to get eaten, okay? That's not why startups do patents, okay? They do it to increase their valuation, right? This is an asset the company has. And if I do my job right, it means that every time you raise money, the patents contribute to the value, okay? And I pay for myself many times over, especially at the exit, right? When you sell your company to Google or Facebook or Huawei or whoever, the patent portfolio can make a huge difference, right? And I have seen cases where an acquirer looked at several companies and bought the one with a really good patent portfolio, and the other company just closed their doors 2 weeks later. Company A, almost $400 million. Company B, sold to creditors, nobody got anything, right? And part of that, not everything, the CEO of company A was a really nice guy and good to work with. Probably that mattered just as much, but the patent portfolio made a big difference. Company A had a really well-developed patent portfolio. So that's the goal. That's why we do patents for early stage startups, right? And some of my presentations will talk about making patents valuable. And really, that's a strategy discussion. And maybe we'll get to that, have time for that here, but we'll see. Okay, that's why you do IP. So the question, the answer to the investor about competition is, we have these features that we think are so much better that are going to drive customers to us. We have some advantage, right? Okay, we have a better way of getting users. We have a feature that people won't be able to do without. That's the answer to that question, all right? You could have a situation where you're looking at a blue ocean opportunity, right? I have a client right now and we're using that term. Blue ocean means there's not much else out there, right? And they were called blue ocean by one of their big company partners. It's like, you know, you've got at least 2 things that are blue ocean here. And, you know, that is really going to help get them in there. It's going to get them in there with this partner. And that's how you fight off the competition, right? There's better answers than, oh, we have a provisional, okay? Okay, that's why we do this. Okay, mistakes. And I have a presentation that I give that's the top mistakes people make. And this is the list, mainly the list right here, but I will do a whole talk on these points right here. The top 2, and it is 2, not 1, but 2. The top 2 mistakes that people do is ownership. It's number 1 and number 2, because there's 2 types of ownership. Do you own your own IP? And do other people own IP on what you're doing? Okay, your own IP and other people's IP, right? As I said in the beginning, a lot of creative work, copyright, inventions, patents, they start off being owned by the inventors or the creators. Right? And there's some differences in different countries, right? And there's some countries in Europe, there's a much bigger presumption that IP is owned by the company, the employer, right? But I'm not a Spanish or German patent attorney, right? I'm a US patent attorney. So you have to ask them about the details. But here in the US and in most of the world, it's really important to make sure that you transfer ownership of your ideas, of the inventions, to the company. And that means everybody involved. It means the co-founders, there has to be agreements between them and a transfer agreement where in exchange for their shares, the founders are giving all their rights in the technology over to the company. Right? One of my favorite examples is Adobe Forms, right? We all like to use Adobe Forms. And that was invented by a sales guy, right? So, you know, he was looking at what the customers needed and said, hey, wouldn't it be great if we could have these forms in here and people would fill it out? That's great, right? That was like 22, 25 years ago, right? So make sure that everybody you can get has a duty to assign technology or ideas that they have to the company, right? And of course, there's going to be issues if you have a software development firm working for you. They're going to be much more restrictive in what they'll transfer or what kind you could have in an agreement. But the stuff that's focused on your business has to be transferred. It also matters what state or country your employee is in. So in California, the default of what could be owned by the company is a lot different than it is in Florida. And don't ask me about Poland or Malaysia, all right? Okay, so the local country laws are going to make a difference. In Florida, it's possible to have employee agreements that really are broad, where any idea that the employee has, even if it's not really well related to the company, could be grabbed by the company. In California, the rule is different. If you are a software company working on databases and the employer invents a new lawnmower, that is not covered, okay? Other places could be different, right? So anyway, you want ownership. The last thing I'm going to say about ownership is things like Upwork. In those agreements, right? If you go and post a job on Upwork or some of these other work for hire platforms, there's a checkbox somewhere in all that stuff that says IP transfer. Anything here produced here gets transferred to us, right? If you don't check that box, you don't own it like you might think you own it. And I've seen people do this where they've hired somebody to do a company logo, right? And they got the logo, but they didn't get all the copyright to it or some other feature, right? Some other ownership right. And 10 years later, the guy who originally wrote that, who turned out actually be somebody totally different than the one they hired, right? Says, hey, I actually produced that and I have a copyright. So boom, right? So be really careful, be aware of other people's, that you make sure you own your IP. The other type of ownership is, of course, other people's IP. You don't want an employee to get some code that he wrote 5 years ago for a different employer and decide to take the whole afternoon off and say, oh, I already did this print routine where we take the application, the user data and put it in a nice format. I already wrote that and we just use it again, right? You want to make sure people don't do that. You want to be careful about things like open source. If you use open source, which you can, you have to be very careful and read the open source agreement to tell the truth, haha. There was a company, or there is a company, maybe not for much longer, called Truth Social here in the United States, founded by somebody who won't, we don't need to mention, but they tried to start a social network and they used open source code. And the open source agreement that they tried to use last year required that they publish their entire code base, right? So they made the announcements, hey, we're gonna be ready with this new social network, boom, boom, boom. And then the manager of the open source code said to them, yes, please, you have 30 days now to publish your entire code base. And they had to pull back. and restart from scratch. It was really embarrassing. Okay, this was a bad intellectual property move and mistake. There was some not so good attorneys somewhere who didn't give the right advice. Okay, waiting is number 3. You don't want to wait too long. You want to file sooner rather than later. If you file a provisional application and it turns out you had 2 children in the intervening year, well, anyway, 1 child, okay, and you were kind of busy, you can just refile that provisional, right? You'll lose some priority date, but get something on file now and push yourself to then get something done within the first year, right? No strategy is a common problem, right? The engineer said, this is cool. Your customers don't care. Or the engineer said, yeah, I saw a problem, so yeah, it was obvious to fix it this way. The customers are so excited, right? The problem wasn't obvious. The invention isn't obvious. You could get a patent on it. Even, this is something about inventing. Half the time it's understanding and realizing the problem. And once you understand the problem, the solution or a bunch of solutions become pretty, oh, we could try this or this or this. Nobody had realized the problem before, right? That's possibly a patentable invention, right? So yeah, patent things that make a difference to the sales, right? That the sales and marketing people like. I don't care so much about engineering, but I want the sales guys to say, we're the only one who's got this. So here's the price. How many do you want? Okay, that's where the patent strategy should go. There's a lot more to it. There's a lot more details and how you can form patent strategy. But that's I don't have time for that in this presentation. Finally, number 5, understanding the patent. This is again the story of the person who comes to me and says, I got a patent, and look at this fantastic, it's got everything in the claim, right? It's got 50 lines of text, right? They don't understand that that is an extremely narrow claim that would be so easy to get around. And it's got all those words to describe what they think their invention is, but only covers exactly that. Nothing beyond that, only exactly that thing, right? So understanding the patent and understanding your competitors' patents and your own patents, and being able to work with a patent attorney, you should be able to understand what it means when they edit claims and what claim language, what that really means, okay? So come to my talk in a month or 2, and we'll go and do the deep dive. It's going to be called Anatomy of a Patent, I think, something like that. All right, that's it. Mistakes. Okay, already we talked about this one. Okay, owning your own IP, right? No, I'm not going to repeat this. Okay, ownership initially vests in the inventors. There's something that here we have called in the US, and almost every other country I know of has a recording practice, just like when you buy and sell a house. Ownership of patents are recorded in the US, are patented at a recording system at the patent office, right? So you can go and look at patent number, and you can see who the original inventors were. Maybe there's an applicant that's a company, right? And then you can look on the patent at the USPTO, and you can look up who the current owner is, and there'll be a record. The inventors transferred it to this entity, and then this entity transferred it here, and then it was transferred to some individual person, and then back here into a new company. It could be that a patent goes through many different changes in ownership, and it's still pending, right? So make sure that you execute the assignment process. I have seen situations where other attorneys have made a mistake. They've gotten a patent in a judgment of some sort, right? Or in a divorce, okay? And they say, okay, we got it. But they didn't record it, right? So that the legal ownership was never really properly changed. And if that goes on for long enough, somebody else can come in and transfer ownership again. The guy who's the registered owner might resell it, right? And then there's a problem, right? There's legal costs and lawsuits, and maybe ownership doesn't get transferred back, right? So that's it. You got to understand that there's an assignment process, right? And then we already talked about owning other people's IP. So there's a couple of points here that I haven't talked about though that I like, right? One of it is the startup viewpoint. If you're a startup, your viewpoint about other people's IP is different than if you're a big company like Intel. The reason is that if Intel learns about patents, it implies liability. It might mean that the patent holder can say, oh, well, you knew about this, so we get more damages, right? In a startup, it's different. As a startup, you're flexible, right? If you find out about somebody else's patent, you can work around it. If you can buy it, maybe you can get a license, maybe you can improve on it, right? So in my background, is as a scientist. I was a CTO for most of the 90s. My point of view is read the literature, right? If you're in a startup in a space doing dating apps, go read up what you can, do searches on eHarmony and Tinder and all these people, see what IP they have out there. It'll give you an idea of what you might get, right? You might read something in their patent application that gives you an idea and say, oh, we're doing this in such a better way. We could take what they have written here and our idea and come up with something really cool, right? So reading literature is always helpful, okay? Keep good records. I mean a notebook, right? I'm gonna give an example in a minute on this, but have a bound notebook. And when you go to a meeting, open it up and start writing, right? I do that in a certain way. When I am in a virtual meeting, I take notes and then on a Word document. And then after the meeting, I transfer that to OneNote. And I put in a bunch of keywords so I can find them later. And I have a record where I save those documents and so on. So I keep an electronic version of notes. But the best CEOs that I know, they come to meetings with these notebooks in their hand. And they flip it open and they start off a meeting with Dr. Colby, discuss patent, blah, 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 right? And they have a record of every meeting they go to. And it's so useful. It documents in a good way what we talked about. Imagine you have a meeting today with there's 3 of you and you're all founders. And you take notes on this great new idea for a flying coffee cup, okay? And it flies from the coffee maker over to my desk. It's a drone coffee cup, right? And you have this great idea. And you get funding. Everybody loves it. A year later, or 8 months later, you hire a top engineer from one of your flying coffee cup competitors, a company that sells drones. And 2 years later, that company sues you for trade secret misappropriation, meaning you hired away our employer and he gave you all of our secret plans on flying coffee cups. And it's going to kill your company. I mean, it's going to be a multi-million-dollar lawsuit. Even if you win, you lose, you're dead, right? Well, it's a good thing that you have this notebook from now 3 years ago or so, where you had this meeting with your team and you went over that and you wrote down all the little ideas you had about flying coffee cups, right? Boom, that lawsuit is only going to cost you $50,000, not $3 million, okay? So that is the advantage of keeping records. And I can come up with lots of examples. You have people in a meeting and you're throwing around ideas, right? And an invention can be the result of groupthink. An inventor is somebody who contributes to the conception of an idea in the claims. Doesn't matter what's in the spec. For inventorship, you look at the claims. If there's something in the claims and somebody contributed to the conception of that idea, they're an inventor. Even if it's just one phrase in one small claim somewhere, right? One out of 50 claims, if it's one, they're still an inventor, right? So you have a record at that meeting of who you wrote down. Susie had this idea, Joe had this idea, they worked it up and they came up with this, right? So now you have a record of who suggested things, and that is very useful to patent attorneys. Like, who came up with this? If there's a dispute, there 2 or 3 people were keeping notes. That's great. So keep records. Right? That's favorite. Okay, let's moving on. We're going to talk more in detail now here. Well, strategy. Okay, we talked about this first element. Marketing, patents are for well, first, they're for valuation, okay? But in your strategy, you want to hit the patent the things that make your company really valuable and sells products or services. So patents should really get excited your marketing and salespeople, right? Okay, it should be product driven, focused on valuation. And if you do it right, and this is my quote, make IP more than just a checkbox. I'm going to put a little trademark symbol next to that, okay? Make IP more than just a checkbox. Let me give an example. You're going to do your A round and you are asking for $10 million at a $50 million valuation. You have given a great presentation and there's 4 things that you're telling the investors. These are what has made this company fantastic, why our sales are going through the roof and why we're going to be the next unicorn and your investment ever. Okay, these 4 things. And then you have the next slide and it's those 4 things in a cluster map. And I'll do this for my clients, right? For no charge, even for no charge. And it's 4 bubbles on a PowerPoint slide with those 4 items in it. And then a dozen bubbles around it with all the different patents and patent applications, right? So here's the patent that covers this feature and this feature. And here's a patent that covers just this feature. And I draw lines between all of them and make it look like a big spider web, right? That wasn't my idea. The idea of the founder of the law firm I first worked for, John Farrell is his name. And it really conveys to the investor the value of the IP portfolio. It makes IP more than just a checkbox, okay? And I have had people come back to me and say, yeah, that slide opened their eyes, right? Literally, the other way is, oh, we have 6 issued patents and 8 pending, and on a list, right? So this opens people's eyes and it can increase the value of your company and get you more money for less equity, right? That's my goal. All right, strategy, make IP more than this thing. Okay, IP can make you richer, not more like a Richard, but richer, okay? This is seeing the light, right? The goal of a startup is to get IP started so that you can convey the value in the company and convey the value between the IP and your products or services, right? And that's why most early stage companies who are in the tech area, who are getting investor money, right? Who are getting angel money or VC money, really need to consider IP very seriously. Now, if you're a new bakery, right, that may not be so important. Oh, let's take the example of an ice cream factory, right? Well, it turns out that there was one time in my career that I had 3 different companies doing ice cream, right? 2 of them were just trademark clients, but one of them was doing patents on manufacturing ice cream using liquid nitrogen, and they had an automated system that made it really reproducible and made a nice show. It was fantastic, right? And they exist. They're in the Bay Area, right? I go eat there sometimes. Okay? So they were an ice cream company that was a tech company. Okay, they are successful. So there's a good chance that IP is important. If you're not a tech-oriented company, if the things that are going to make your company so successful are your sales ability or the quality of your workmanship, then you will probably more want to consider trademarks. Okay, right? If your company depends on producing creative art or materials, right? Copyright could be really important to you, right? So I saw a photographer just recently, if I can talk about this, who was really good at doing pictures of resorts and things like that, right? And it turned out that the copyright in those materials was really important, okay? So that person's business, it wasn't patents, but copyright that made a big deal. Okay, we're moving on, okay. Oh, I promised I would do this. I would talk about money, and before I show this slide, this is, of course, here's all the disclaimers, right? Your experience may vary. We got to do, so this is kind of a ballpark thing to give you an idea of what you can budget for, right? And this is, again, I'm based in Tahoe, California, and or not California, in Nevada. I spent a lot of time in Silicon Valley, and I did most of my career there. And this is a California Silicon Valley type cost, right? So here's the numbers. Ready? Hold your breath. Drum roll. Okay. This is an example of what you might expect for patent costs. And I have two things here. I have provisional filing and a two things, right? And non-provisionals, and then actually with the patent issuing. Okay. So first, let's talk about the provision. There's a book on Amazon called Patent Pending in 24 Hours by Nolo Press. I think it's about 40 bucks. Okay. As a micro entity, the filing fee for a provisional right now is $75. Okay, so you can do it for less money, right? You can take your idea, write up what you want, and do it yourself. I don't recommend that. If you're starting a company, you should have some money in the bank. The last thing you want to do is be worried about rent payments or mortgage payments or putting shoes on your child, because the investors will see that, they'll feel it, and they will hold you over the barrel, and you'll find yourself paying a lot of equity for any money you get, right? You ought to have some money in the bank so that you can run for a year, right? Even if it's just supporting yourself. And so my suggestion is that you work with a patent attorney, right, in order to put a provisional application together. And that will avoid many of the mistakes that can be found in a provisional application. I usually do this, and it depends on the client. With rare exceptions, sometimes the money, it's more, right? I say $2,500 flat fee. And what they get for that is they get maybe an hour and a half of a disclosure meeting with me. And in which time they explain to me as much as possible about their inventions and their business. I got to know about the business too. Right? If the patent attorney doesn't ask about the business, you're not going to get a patent that relates to business. So, okay. $2,500 gets you that disclosure meeting. I will come back with you with maybe some drawings, depending on the type of patent, right? Some block diagrams and flowcharts for a software patent, for instance. Then maybe a summary and a set of claims, a fleshed out set of claims. I also give you an outline, and I'll base that outline on the claims. And the purpose of doing that is so that when the outline is filled in and completed, it hopefully has enough stuff to support claims, and we can use those claims in a later non-provisional application. It won't have as much meat, right? I don't think, well, that's not true. I have a case right now where I did this for somebody, and they came back with almost a 50-page document, right? Most people don't do that. I mean, I get 5 or 10 pages, right? And that's definitely not got as much stuff in it. It's that as a full non-provisional patent application, which is 30 to 50 pages, okay? That gets filed, there's the filing fee, everything's included, it's a flat budget of $2,500. And so that gets you a provisional patent application that is likely to be really useful to you later, okay? That's in combination working with an attorney. And I'm sure that whatever patent attorney you talk to ought to be able to do that type of thing for you. If they can't, they're the wrong person for you. Now, a full patent application is generally entirely written by an attorney, okay? This means we've thrown out a lot of stuff, sometimes not, but usually a lot of the provisional is rewritten, okay? Because there's a lot of formal requirements and there's a lot of wording you want to use in a non-provisional application. If something's really going to issue as a patent, you'd like to have an attorney have written it, an experienced patent attorney, right? And this means not some low-level associate that you've never met. It means the person you talk to and you're dealing with is the person who's doing the work, right? I put a number here of about 18,000. This is US dollars, okay? That should get you a 35-page patent application, roughly, including the figures and claims and everything, double-spaced, US paper, okay? It could vary. And I have seen over 20,000. I have seen under 15. It just depends on how much meat there is. I have written 20-page patent applications that were basically on one tiny little material processing step in semiconductor manufacturing. And it only took 20 pages. It was not 18,000. It was more, well, nowadays it would probably be more like 12,000. Okay. So it'll vary, right? This is just to give you an idea. That gets your application on file. Right? It doesn't get you a patent. Remember this later when you talk to your attorney and said, well, I thought that was going to be it. Okay. So, and I see it's 6, so I'm going to wrap this up. Okay. There is things then getting the application into a patent. And there's things called office actions where the patent office writes back to you and tells you everything you have is garbage. And most of what they say is garbage. And when they say that everything you have is garbage, is also garbage. So there's a chance that it's not garbage. It works out. 95% of the time, all the claims are rejected on the first time, right? And your attorney has to write back to the patent office or call them or do what's called an office action response and make an argument of why the examiner is wrong, or amend the claims so that you're asking for less scope and to avoid some piece of prior art. On average, that happens about 2 times, a little under 2 times average over all patents. It can happen many more, right? It could happen none. I have had cases where everything's allowed, right? Usually that's not the first patent in a family. Usually by then we know what is going to make something allowable, right? And we're going to get to families in just a minute, okay? On this slide, hold on. So typically over 3 or 4 years, you might have spent $30,000 on a patent when it issues. And again, just to give you a general idea of the cost. This is one patent in the US. If you're doing stuff overseas, it's completely different and depends a lot on the country, right? Is there translation involved? Okay, there's foreign patent attorneys who've got to be paid, so that you can imagine adds to the cost. So, and this is a thing I'm going to talk about when I talk about anatomy of patents. There's patent families, and this means a patent can have a daughter. So if I file a patent 11 months ago, a provisional, and next week I file a non-provisional, right? I have 2 related applications because the non-provisional claimed benefit and priority to the provisional. 6 months later, I might have more to add, right? In the US, I can file what's called a continuation in part and file another application that claims benefit both prior, right? I get the priority dates for whatever material on the date it was first introduced. So that means the provisional has some material, and I get the priority date for that material back then. I get the priority date of next week for whatever was in the first non-provisional. And then the daughter of that application could be a CIP, which means continuation in part. If there's new material there, I get that filing date of that app for that material. And this can go on, and there are great-grandchildren. And I have seen a case, I've seen a typical case where there in a year somebody filed 8 provisionals, right? And then they referenced all of those in one non-provisional. And over the next decade or so, they've gone back and in a serial manner, one at a time, gone to each provisional and filed different non-provisional patent applications on this whole family. And as long as you have something pending, right, with a priority date going all the way back, you can continue to do this until 20 years almost passed. And sometimes people do it really close to expiration. I mean, there are patents that will expire really right away. The reasons you do that is there might be different claims. You realize that something was important, but you didn't have it in the claim, right? The technology has gone in a different direction than you expected. It's very common to take an initial patent application and grow an entire family from it. So the advantage of that is, and then the lower line here is supposed to be pink, family members are much cheaper. So if I take a patent application that's 40 pages that I've already prepared for you, and I add 5 new pages of new material, you don't have to pay for me writing 45 pages. It's only the 5 new stuff, right? So I've gone back and looked at existing portfolios for my clients. And once they're, they have 20 applications running, the cost of a new application has dropped to like 9,000 to 12,000, kind of in that range, right? And that's because we're reusing material. So as you grow, when your company is 5 years old, you will be doing more IP, but it'll be more efficient, right? The cost will be better. Okay, here's one more statement on costs. When people come to me and they're a Silicon Valley early stage startup, let's say a new healthcare app, they ask me, well, how much are patents going to cost me? And I say, and again, it's just ballpark numbers. In your first year after funding, when you've raised $500,000 or $1 million, you might put in a budget of 35 to 50,000 for IP, including trademarks and some patent applications, right? If it's the technology to your company is really the key that is going to make it a winner, you might have more, right? If you're a company that makes the ag company that's making special seed packets, you might only have one, right? It may be less, but that's just a ballpark, right? So if you're putting a budget together, depending on how aggressive you're going to be, and the investor asks, yeah, we've budgeted 40,000, 45,000 for IP in the next year, and we expect to get 2 trademarks, and we plan to file 2 or 3 patent applications, right? Some provisionals and maybe 1 non-provisional. Okay, that's it. I am now going to first look at the question and answer field. Wait, I have one last slide, the special one. Okay, Ramon Law is a semi-virtual law firm. That means we have a completely different cost structure than most law firms. I joined them just before COVID hit, which was really nice. Okay, so life went on for me really well. Semi-virtual means we do have offices. We actually have 45 offices around the world. I'm associated with our office in Truckee, which is next to Lake Tahoe, and in our Menlo Park office. I actually go in person probably to our San Francisco office more. But our offices are small. There's a couple of conference rooms, maybe 1 or 2 attorneys that work there, and a receptionist, right? It's not a full everybody comes in office. Most of the attorneys work at home. Most of the staff work at home, right? So my admin works in Canada part of the time and in Carson City, Nevada part of the time. We're about almost 200 attorneys and 14 countries. We're also a very flat law firm. So most of the attorneys at Ramon, I believe, have over 20 years experience. This is very different than the big law firms that you're used to dealing with that are a pyramid structure with 1st and 2nd year associates at the bottom doing all the work, 5th year associates supervising them, and the top of the pyramid having a bunch of partners just doing business development and showing up for meetings just to charge $1,500 an hour. So we aren't like that. We're very different. Here is my email and my work phone number and my LinkedIn connection. Please feel free to reach out on LinkedIn for me. I do have a lot of connections, but the best way to get a response is email. And I'd be happy to talk one-on-one with anybody who has any specific questions we're not about to cover, because in the next 22 minutes, I am going to cover the question and answer section first. Okay, Matthew starts off. Welcome, Matthew. Does the provisional patent application give you 1 year lead time to file full patent application only in the US or worldwide? The provisional application can be used as a priority date for worldwide coverage. If you're going to file outside the US, at the end of that year when the provisional is still pending, you have to file what's called a PCT application. And that stands for Patent Cooperation Treaty. And it's basically an option. You pay some money, expensive filing fee, $3,000 to $4,000 typically, depending on the size, right? And and the size of your company, the size of the application and the size of your company. You pay, and that gives you 18 to 19 months to decide which countries to go into. And that's really useful because hopefully by then you have a bigger budget, and by then you'll have more knowledge of where it's really important, okay? The reasons you pick specific countries. Where are you going to be doing business? Where's your customers, right? Where are your competitors, right? So a while ago I had a client whose big competitor was Canadian, right? So we did everything in Canada, I mean, everything we did anywhere, we did also in Canada. Right? And then where your potential acquirers are, right? So if you think a Chinese mining company is going to buy you, right? Gold and silver mine, or coal company is going to buy you because your technology is on how to gasify coal in a really economic and environmental friendly way. You might file in China just because that will be really valuable to that company, right? Or same with Korean companies, Japanese or Australian or European companies. If you think Siemens is going to buy you, well, by all means, pick the right countries in Europe to get your patents, right? So that's the selection, and hopefully, after another 18 months, so you have 12 months of the provisional and then 18 months more, you'll have a pretty good idea of where your company is going, what the budget is, and whether it's even reasonable to do foreign filing. Okay, and your attorney will talk about the costs of that. Okay, next question. That was a great question, Matt. Thank you. Okay, so Sun Keat is asking, what's the rough cost of a provisional patent application for a SaaS product? I think I covered that. And it will vary depending on how much attorney time you want. Okay. But yeah, you should do, I do provisionals for software, including SaaS, at $2,500 for a flat budget. Okay. And sometimes, very often, I find that that's just me investing in the company because I'm hoping that a year later, of course, they're going to do a non-provisional, and I'll spend a lot more time than I hoped. But there are some outliers where I end up spending 10 hours on this instead of 4 to 6, right? Okay. Anne is asking, how do you determine the value of a patent pre-revenue? Great, thanks. Yeah. So there are people who do professional job, who are professionals in valuing patents and patent applications, right? And I've had clients do this, and sometimes the numbers are sensible, and sometimes I disagree with them one way or the other, right? Valuing a patent is like valuing your spouse or significant other, right? It's in the eyes of the beholder. A patent, I'm thinking of the chicken pecking on the floor of the barn and accidentally hurting its beak on a huge diamond. Okay, it wasn't a seed. The chicken is unhappy, right? The patent has to fit the acquirer to be valuable, right? If a patent clearly is infringed, like an issued patent is clearly infringed by others, there could be value on it. You can sell it to somebody else. You can get financing. One of the things I don't know if I covered, but yeah, enforcing a patent is a multi-million-dollar project. So if you're a startup and you turn into a company that's just enforcing your IP, you're probably no longer a startup, you're a patent enforcement company. And I've seen it happen where a startup has a good patent portfolio and they talk with a big company, let's say Microsoft, and after 6 months of discussion, Microsoft suddenly goes quiet, and a week later they issue their exact copy of what they've been pulling out of this poor startup all last time, right? And that company goes from 40 to 2 employees, and they've become a patent enforcement company that will get money, probably is likely to get money out of Microsoft, but they probably would have done better as a company, right? I mean, I do think that it's better to build companies than just write patents, and if you can, right? So it's not always easy. Let's see the value. So what's the value? It really depends on what a good match it is, right? I have seen auctions sold for a lot of money, but it kind of comes and goes. I mean, sorry, patents sold at auction for a lot of money, but it's a fad thing. Is it? I have personally sold patents, and it's a single patent isn't worth a lot. I mean, it's not worth millions usually, right? It might be worth under 100,000 if it's something that's, it really depends. And there are brokers. There are people who buy and sell patents that I know who are really good, and they know their technology. They specialize in a certain space, and working with somebody like that can be really useful. But it depends. The way you express value is to do that cluster map, is to tell your investor about the things that make your company so special and then relate the patent to it. That's how you express value of your IP patents and patent applications, pre-revenue, right? Somebody's asking, Michael is asking, what's a notice of allowance? A notice of allowance is a happy day thing. It is when the examiner, the patent office, issues a document to you saying that the examiner has agreed to you, finally, that the current claims in your patent application are allowable, and that if you pay the fee, which is not cheap, $600 or so, you will in 6 to 8 weeks, you will have a patent issued, right? So notice of allowance is the last thing that happens before you pay the issue fee and your patent issues. Good. Please go over that pitch slide with the 4 text bubbles. Okay, I'll do this one more time. And I think I should probably put this in somewhere in one of my presentations. So what I like to do is called a cluster map. And I like to list the 3 or 4 things that make the company really fantastic in 3 or 4 of those bubbles, colored red. And in the red, so those are listed in text there. And then surrounding that, I have blue or green bubbles that list all the pending patent applications in blue and maybe issued patents in green. And I put those all around the middle bubbles. And then I draw lines between them, representing this patent, issued patent here, covers these 2 silver bullets, these 2 magic things that make your company really valuable. And this one covers 3 of them. And there's 3 lines drawn in that slide, right? If you write me an email, I'll send you the slide. These are, the idea here is to show the relationship between, and there might be better ways to do it, between the patent portfolio and those features, those key silver bullets that make your company really successful, or are going to make your company really successful. And that's what makes IP more than just a checkbox. Okay, right, next question. There's so much, yes, I am going to, and if you haven't, use this email, start bugging. It takes a day or 2 for Zoom to finish the processing the recording, and then it goes to my marketing group and they will put a cover letter. You will get a link to the recording and a copy of the slides within 7 to 10 days. That's my target, okay? A design patent and a copyright. My headset just said battery low. So a design patent, there's potential that it could cover both, but a design application is like the speakerphone I talked about. I just dealt with a design application that was on a charging plate where you put your iPhone at night and it does those RF remote charging, right? It had some curvature to it and some rounded edges, and somebody had a design application on it, right? And that's not a copyright. There's not, yeah. It would be hard to express that as a copyright. Copyright is more artwork. I'm sure there's some overlap somewhere. I have always thought that copyright and trademark with a cool looking logo should have more overlap than possible. Anyway, but I'm not an expert in that space. Okay, if you're David, this is the last question because my headphone's about to die. Okay, if you're presenting a novel concept to early insiders, is a patent abstract better than the product and an NDA? I would try to get everything you can. I would try to get a provisional patent filed before you talk to anybody, right? That includes whatever you're going to tell them. And then I would try to get an NDA. Most investors won't do NDAs because they see much too much. It's really not practical. I know VCs and they see 500 to 1,000 pitches a year sometimes. If they're sturdy enough in their firm, they'll have to go through all these, right? And there is plenty of overlap between pitches, right? I have seen literally the same pitch 5 years later. It's like, I know the company that did this and they failed because of that, right? Yeah, try to get it whatever you can, but do not expect investors who are really experienced, who are professional investors, to sign an NDA. That's very hard for them. It's not something they can deal with. because they see too much stuff. Get something filed. Ask them that it be confidential, and that they, you can say, please, if you're going to send this to somebody else, please ask first, right? That's good manners. A VC will look at something and go, oh, Joe here has a client in the space. Well, I'll talk to Joe what he thinks of the space. Is it a good investment, right? They will do that, right? They'll talk with each other. So if you really want something to be confidential, keep it that way. If you're doing a presentation in front of a room full of people, if it's specific invites, maybe that's confidential, and the invite said this is a confidential discussion, maybe, but the law might be different in the UK than in the US, so you don't know. If there was an open meeting where anybody could sign up, that's not confidential, right? And you can, a good pitch will leave a lot of stuff unsaid that'll make the investor want to drool and learn more, right? Okay, let's see, we got one more from Jonah. My main competitor has an active utility patent with 3 independent claims. I want to know more about what the bare minimum entails in each claim. I was told there are typically ways to work around software patents, but they can't be. But the competitor's patent has described an unusually broad, and most software patents are not as open-ended and encompassing. Yeah, you got to look. This is a, there's 2 ways to attack this patent claim. Let's just deal with this one claim. You could find prior art that has everything in it, or an obvious combination of prior art, and then go to an attorney and say, is this patent really valid over this prior art, right? And if it's really clear-cut case, the attorney might be able to give you well, that looks pretty strong. A formal legal opinion is expensive, right? It's a huge document with all this legal analysis, 50,000, right? Maybe, I mean, big money, right? If it's 1-for-1 straight in, you're in, that's easier, right? The attorney may not give you a qualified legal opinion, but he'll go and say, yeah, that looks pretty good, right? Or more often to me, there'll be an investor who has a piece of prior art who has concern, and I'll sit down and have a verbal discussion with the investor, right? The other way to get around this patent claim is to not do something in the claim. Right, and from what your comment here is, it sounds very broad, so it might be hard for you to avoid. So this works from both directions. If it's really broad, there's an increased chance that there's some prior art out there, or that obvious combination of prior art. But if it's really narrow, then it's harder to get around. But again, the best thing to do is talk with a patent attorney. And the other thing I would do, if you have this competitor, go look at his patents and think of improvements on his stuff or her stuff, right? Their stuff. Go look at what they've done and think of all the ways that you could use your ideas that are, you've got more than just one idea, right? How you can improve on theirs and start filing patent applications all over them, right? Get a offensive patent portfolio that can really be used as a tool, as a big defense. So if they ever come after you, then you say, well, we have these 4 other patents that we've got that are all improvements on your stuff. So I think we're going to be able to sit down at the table, and we've got more cards than you have, and we're going to have a really fair negotiation here, because you're going to be in just as much trouble. For an example, that's what AMD did to Intel. Right? They were way behind when they were founded much later, but they would actually have meetings where they would look at Intel's published product roadmap and say, okay, let's try to cover this and this and this and this, so that when it finally Intel came knocking on their door with a bunch of IP, they said, well, yeah, but we've got all this, right? So, right, we'll try to level the playing field. That's it. Look at ways to trump over them, so that 4 or 5 years from now, when things come to a head, you're in a stronger position and the negotiation goes much better for you. All right, I think that's all the questions. I see an email from Dale. I will send you the cluster map. Okay, and now I'm looking quickly at the chat because my headphone is going to stop. If I just become quiet, that's the end of it, folks. Okay. Yes, good. It was good to have so many of you here today. How many did we get? Okay, 35 people. And I'd like to thank Yoshi again for coming on. Yoshi is the one bird. If you didn't come in early, you missed Yoshi, the one bird who knows more about patents than any other I know. Yes, somebody's asked, Sylvia is asking, yes, I will send out a link in 7 to 10 days. Do I start applying for international after you get your US patent? No. You have a year from your first filing, from your provisional, to start filing outside the US. And there's a thing called a PCT application you can do to delay most of those costs. Your patent attorney should advise you on that. But you're okay filing in the US first for that 1 year, okay? Thank you, you're welcome. Deep dive should be good. And the deep dives can be designed for people, not just founders, but for, C-level executives, which should be interesting. Great, that's it, folks. We're actually ending 5 minutes early. And I want to thank Rob and Idea to IPO. I did notice one thing in Jennifer's intro. Idea to IPO is now having in-person events in the Bay Area and San Francisco Bay Area. And I think
IP